Under the Comprehensive Environmental Response, Compensation, and Liability Act, or CERCLA, parties that contaminate a site with hazardous materials are deemed potentially responsible parties, or PRPs, and must pay to clean up the waste. But can one PRP sue another PRP to help pay for cleanup costs? We'll see what happens when a PRP tries to sue the United States to recover cleanup costs in United States versus Atlantic Research. Atlantic Research leased property at a naval ammunition depot operated by the Department of Defense and retrofitted rocket motors for the United States. As part of the retrofitting process, Atlantic Research used pressure washers to remove and then burn pieces of old propellant in the motors. The wastewater and burned fuel contaminated the surrounding soil and groundwater at the depot. Due to the contamination, Atlantic Research became a PRP. Atlantic Research cleaned the site at its own expense, but later sought to recover some of the cleanup costs from the United States. Atlantic Research sued the United States in district court for recovery under CERCLA Section 107A. The United States moved to dismiss, claiming that Atlantic Research couldn't sue to recover cleanup costs from another PRP under Section 107A. The United States also claimed that allowing recovery under Section 107A would create conflict between Section 107A and Section 113F, which the United States believed was the exclusive section of CERCLA that allowed PRPs to recover cleanup costs. The district court agreed and granted the motion to dismiss. Atlantic Research appealed. The Court of Appeals reversed and held that Section 107A 4B gave Atlantic Research a cause of action to sue. The United States Supreme Court granted cert.